Okay. So while we start the webinar, we'll just give it like 5 minutes for people to join, because I'm going to start joining now before we start the deliberation.
Big events? Do you have meetings, conferences, seminars, arbitral proceedings, or even workshops, and you're looking for a venue to book? Well, look no further. Take your event up a notch with state-of-the-art facilities in our conference room, meeting room, and hearing room. With free internet, printing services, and other freebies, the Nigerian Institute of Chartered Arbitrators can accommodate all that you wish to hold at convenient and price-friendly rates. This is because, with our well-structured, conducive atmosphere and our spacious, beautiful, and affordable venues, you are rest assured on a successful meetings and arbitral proceeding. For more information and inquiries, kindly reach us on info@NICArb.org or call us on 090-871-87413. You can also visit our head office at 10 Adeleke Close off Freedom Way, Lekki Phase 1, Lekki, Lagos. The Nigerian Institute of Chartered Arbitrators, promoting ADR since 1979. Hey there, ready for your next big event? Do you have meetings, conferences, seminars, arbitral proceedings, and workshops, and you're looking for a venue to book? Well, look no further. Take your event up a notch with state-of-the-art facilities in our conference room, meeting room, and hearing room. With free internet, printing services, and other freebies, the Nigerian Institute of Chartered Arbitrators can accommodate all that you wish to hold at convenient and price-friendly rates. This is because, with our well-structured, conducive atmosphere and our spacious, beautiful, and affordable venues, you are rest assured on a successful meetings and arbitral proceeding. For more information and inquiries, kindly reach us on info@NICArb.org or call us on 090-871-87413. You can also visit our head office at 10 Adeleke Close off Freedom Way, Lekki Phase 1, Lekki, Lagos. The Nigerian Institute of Chartered Arbitrators, promoting ADR since 1979. Hey there, ready for your next big event? Do you have meetings, conferences, seminars, arbitral proceedings, or even workshops, and you're looking for a venue to book? Well, look no further. Take your event up and into state-of-the-art facilities.
Thank you for the short Thank you very much, Admin, for that short advert. First of all, I want to welcome everyone to the Nigerian Institute of Arbitrators webinar on arbitration advocacy. I'd like to say a big thank you and welcome to my panelist and moderator, Mrs. Foluke Akinmoladun, who is going to be moderating today's webinar. Before I turn over the floor to Mrs. Akinmoladun, permit me to just share a few words about the Nigerian Institute of Arbitrators. I'm excited this morning to have with me 3 of our fellows as co-panelists of this webinar. The Nigerian Institute of Arbitrators was founded 43 years ago by the late Prince Agbola, former judge at the One Court NA, 43 years ago with some prominent Nigerians. This was as a result of the fact that he felt it was important that Nigeria has arbitration as an additional dispute resolution to what we all know, which is the litigation. So for 43 years, we've been promoting the domestication as well as the training of Nigerian arbitrators and Africans in general. We have been in the forefront of ADR as a dispute resolution mechanism for businesses, commercial issues. Today, I'm happy and excited to say that for us in the Nigerian Institute of Arbitrators, we are a one-stop institute. Not only do we offer arbitration services as a referral center or arbitration center, we also offer mediation services in training as well as in dispute resolution. And today, we decided that it was important for us to come up with this topic, arbitration advocacy. Having run the center for years now, we have found a lot of the time that when counsels come to the centers, they're not really able to represent their clients appropriately, either because they're ignorant or the techniques of arbitration, or they don't understand the procedure. And sometimes they just kind of have this feeling that because I am a lawyer, I'm able to litigate matters in court, therefore, doesn't matter, I'm able to do the handle arbitration. But we find that it's not like that. So that's one of the reasons why we have put together to this webinar. I just know and I hope that you will all learn one or two things from the webinar. And as we go forward, we'll have better representation of clients when it comes to using arbitration experiential mechanism. So permit me to introduce Mrs. Foluke Akinmoladun, who is the moderator for today's panel. Ms. Foluke Akinmoladun obtained an LLB degree from the Buffalo University. She has LLM International and Comparative Law from the American University in Cairo. She's a managing solicitor of Treason Law Chambers. She's a lawyer, a mediator, an arbitrator, as well as an accountant. And her work experience covers both domestic and international commercial legal matters. Foluke has worked as a mediator in a number of cases, particularly in the banking, construction, family law, property, and real estate. She has also worked as a faculty member and trainer for us, Nigerian Institute of Arbitrators. She has worked as a lead rapporteur and co-rapporteur in international conference, and I can also say in our conference for several years. She has served as a rapporteur. And Mrs. Foluke Akinmoladun has a lot of caps. I would not be able to go through all of her profile. But let me just say that when it comes to writing of articles and making presentations, as well as moderating webinars like this, she's an A+ for it. So Ms. Akinmoladun is going to be moderating today's webinar, and I know that she will do justice to the job ahead of her. Ms. Akinmoladun, you have the floor.
Thank you very much, our dear registrar, Mrs. Shola Shuti-John. Good morning, good afternoon, good evening to all our panelists and of course our attendees from wherever you are connecting with us all around the world. Thank you very much for taking out time to be part of today's webinar. It promises to be interactive, and please do put together your questions as the webinar is going on. If there are questions that you would like to ask the panelists, feel free to use the question and answer platform. Today we have the privilege of having three very distinguished and accomplished arbitrators and arbitrator advocates in their own rights. And I'm going to start by introducing our panel. First, Mr. Adeleke Agbola, Senior Advocate of Nigeria, Fellow of the Chartered Institute of Arbitrators. He is the principal partner of Chikili Chambers, a multidisciplinary law firm which has been in existence since 1954. Mr. Adeleke, Senior Advocate of Nigeria, is a versatile arbitrator and has been involved in arbitration practice, both local and foreign, for over 3 decades as a litigator and arbitrator. He has been involved as an arbitrator either as sole or panel member in numerous arbitrations involving insurance claims, construction, architectural disputes, aviation claims, and intellectual property disputes. Mr. Adeleke was called to the Nigerian bar in 1987, and since then has been in active legal practice and been involved in complex litigations relating to property, banking and finance, maritime claim, insurance, aviation, and employment. He's a fellow of the Nigerian Institute of Chartered Arbitrators and a member of the Lagos Court of Arbitration. In addition to being a member, he's also a member of the NBA, the Nigerian Bar Association, and the International Bar Association. Our next panelist is Mrs. Joy Okungbowa Adesina, Senior Advocate of Nigeria, Fellow of the Nigerian Institute of Chartered Arbitrators. She is a legal practitioner and senior advocate of Nigeria for over 2 decades With over 2 decades of experience, delivering excellent legal representation in every area of the law, helping her clients to fulfill their legal needs. She specializes in matrimonial causes, tortious liability, and ensures her clients always receive a satisfactory outcome. She's used her expertise to advocate in various aspects of alternative dispute resolution. By focusing on making sure that both parties approach and attempt to resolve their disputes through ADR, the Learned Silk has been able to put arbitration and different forms of ADR trainings to use. Over the years, she has served both as representative counsel in the course of ADR proceedings, as well as a member of the panel of arbitrators and sole arbitrator proceedings. She primarily practices in the adversarial court process, and this is in conjunction with her ADR practice. When she is not in the office, she is a resource person at various educational institutions. Our third panelist, and certainly not the least, is Mr. Osahon Idemudia. Mr. Osahon is a legal practitioner and a business advisory consultant with over 34 years of work experience in creating legal structures and framework in complete funding transactions, project development, and finance metrics. Mr. Idemudia, until his retirement from liberal law practice, was the litigation partner and practiced extensively in the Nigerian High Courts, from the High Court to the Supreme Court, both in civil and criminal matters. He remains a partner emeritus of Liberal Law Office. He obtained his LLB at the University of Benin in 1987 and was called to the Nigerian Bar in 1988. He joined Liberal Law Service in September 1989, immediately after youth service, and the Federal Ministry of Justice, and retired after 32 years in the firm. He's a senior counsel at Urogama Legal Practitioners and a strong advocate on deepening the engagement of law as a tool for infrastructural development, renewal, and growth. He is also the vice president of the Wilkie Construction Nigeria Limited, chairman, Global Spectrum PLC, and director at Capital Express Assurance, amongst others. Ladies and gentlemen, I'm sure you will agree with me that we have a stellar panel this morning. And before I call upon our first panelist to speak, I want to give a brief introduction with respect to what we'll be talking about today, which is arbitration advocacy. Now, the concept of a free market economy presents opportunities for disputes in the pursuit of economic gains. And in seeking the determination of their rights and liabilities or amicable settlement of disputes, parties can recourse to the court system or alternative dispute resolution methods. Although ADR includes other methods and mechanisms such as mediation, conciliation, and negotiated settlement, arbitration has, however, become the main alternative to resolving or determining commercial disputes. Generally speaking, ADR has gained widespread acceptance in trade and commercial disputes to the extent that in some jurisdictions, court civil procedures now require that some parties resort to some form of ADR, usually in the form of mediation, before permitting the parties' cases to be tried. So disputes are bound to arise in business relationships and commercial transactions. And the concept of a free market economy presents opportunities for clash of interests and disputes in the pursuit of economic gains. These disputes can be resolved amicably through alternative dispute resolution methods or through a civil action at the law courts. And this brings us to the point of the use of arbitration. And in an arbitration proceeding, apart from the arbitrators, you have the arbitrator advocate and of course the parties. And this morning, for those of us in Nigeria, West Africa time, we're going to be looking into the skill sets and the areas for consideration where an arbitrator advocate, more often than not a legal practitioner, is to present the case of his or her client before the arbitral tribunal. So without much ado, I would humbly call upon Mrs. Joy Adesina, Senior Advocate of Nigeria, Fellow of the Nigerian Institute of Chartered Arbitrators, to please take the floor and guide us through the matters with respect to an introduction to arbitration and arbitration advocacy. Please, Ma, you have the floor.
Thank you very much, Foluke. Arbitration, like you rightly said, is one aspect or one form of dispute resolution which has come to stay. There are other forms of dispute resolution. Where there is a conflict, there is need to resolve such conflict. And arbitration is one of such means. And we have mediation, we have negotiation, we have conciliation as other means of dispute resolution. The chief of them is litigation. However, arbitration is unique in that parties are the ones that are now saying, we want to own our own disputes. We want to own the resolution of these disputes. We want to own the whole process. They decide on their own. And as a result, whatever decision emanates from such resolution, they willingly accept such decision. Arbitration is unique. It is different from mediation. In mediation, parties could decide not to be bound by whatever resolution is arising. Unlike arbitration, where parties, at the onset of their transaction, in the agreement, they will state that should there be any dispute, any form of dispute, we are ready to submit ourselves to arbitration. In mediation, it could be the court that will nominate when matters have gone to court, like you rightly said. The court now has multi-door courthouses, which is a form of ADR resolution center, where the judges refer matters which they feel, in their opinion, need not have been before the court to be resolved amicably. Now, mediation outcomes, are they binding? It depends on the party, because the party can renege and say, I don't want to be bound by this mediation outcome. But in arbitration, there is no renege. You have said you're submitting to arbitration. And if you're submitting to arbitration, then you are bound by the results of the arbitration. The award is binding. You cannot appeal it. You can only apply to set it aside. And in applying to set it aside, the law has made it so difficult that you don't just come and say, oh, no, I don't want this award to bind me again. No, you have to prove that the arbitrator misconducted himself by way of bias or otherwise.
Leonard Silk, we cannot hear you cannot hear you anymore.
Okay, so sorry.
And
can you hear me?
We can hear you now, Ma, but kindly speak a little louder so that our audience can.
That's the volume of my voice. Uh-oh. I think I should have put the microphone. That's the extent to which my voice can carry. Is it loud enough? Okay, thank you.
It's better now, Ma.
Okay. The major difference between arbitration and other forms of dispute resolution is in the appointment of who the neutral will be, and the binding nature of the outcome of a process. Another area is that in arbitration, the arbitrator is appointed either by an institute like the Chartered Institute of, like the Nigerian Institute of Chartered Arbitrator, or by the courts, where the parties have not made provision as to the appointing authority. In mediation, it is the court or parties voluntarily, like in our customary mediation system, parties voluntarily submit themselves to mediation. Basically, the outcome just the difference between arbitration and other forms of dispute resolution.
Thank you very much, Leonard Silk. In terms of the participation of lawyers in arbitration and mediation, can you kindly help us to understand how the work of someone who is a counsel in an arbitration is different from someone who is a counsel in a mediation process?
Oh, well, in an arbitration, the counsel represents the party. But again, the counsel will have to understand that in representing the party, there is a difference between representation in the court and representation in the arbitral process. Because in the court process, technicalities come to play. In the arbitral process, technicality is placed to the background. In the mediation process, usually, more often than not, counsel constitutes plug in the wheel of progress because they want to get exact pound of flesh for their claims. But most times, the claim may be willing to go for less. So at times, counsel are advised to allow parties to talk rather than the counsel. What counsel is to do, you guide your client as to the extent to which he can concede or not concede, or as to the extent to which he can go. But you cannot enforce or force your opinion on the parties, because in mediation, it is easy for the party to say, I don't want this. I currently have a mediation that I am doing. I agreed to some terms which I thought would be okay to resolve the dispute. By the time parties were brought on board, my clients reneged. And I told them, I said, well, we had discussed, and from our discussion, I gathered that with this concession I have made on your behalf, this issue will be resolved once and for all. He said no, that if he is making this concession, then the other party has to make another concession. He brought in a different demand, which was different from the demand we had earlier. So what we had decided to do, both counsel have decided that we push parties forward, let them do their own negotiation. And where we think it is necessary, we come in. But in arbitration, parties and counsel work together because they are submitting their disputes to a third party whom they have agreed will decide or resolve the dispute for them. And in that instance, it's like you are representing your client's interest. You put it in the best form that will result in justice. Justice at times does not mean that your client will have to win. No. I did an arbitration and I was so very impressed. The parties, counsel to the parties were just, at times issues comes up, they said, no, we concede to this and we don't concede to this. At the end of the day, they made the work so easy that within a month, we had tidied up the arbitration. The award was published. I was impressed. I thanked the counsel representative, arbitrator advocate, because it made the work so smooth, so easy, so enjoyable, so pleasurable that I was really looking forward to further arbitration from them. But where a party or a counsel representing a party in arbitration is not conversant, it's not versed in arbitration, he will make sure that both the arbitrators and the parties regret ever coming to arbitration. Because at every step, he's trying to bring in stumbling blocks, which he is used to in the courtroom. I did one recently, and we went to court, we came back, and we're going back to court again a second time. And I had to close the arbitration.
Thank you very much, Matt. So in terms of, so you gave us an example of an arbitration that I suppose from the example you were the arbitrator and the councils were the ones that made it easier for you to arbitrate on the matter. Kindly let us know what were the exact techniques that you saw that helped to facilitate the arbitration process.
Thank you very much. One, no technicality. No technicalities. Both parties understood the rules of the game. We, from the preliminary meeting, we agreed as to the number of systems we're going to have, and we stuck to that. From the preliminary meeting, we agreed as to exchange of documents, and we stuck to that. In the course of hearing, because it was both documentary and oral, in the course of hearing, calling of witnesses, there was no objection, or there were no objections raised as to, oh, why are you asking this question? Why are you not asking this question? No. They put together whatever objection they were going to have, and at the end of the trial, in their written address, they raised the objection. And fortunately, they were all of points of law, and they were trashed out in the way.
Thank you, Matt. So in taking on from this, can you kindly explain, Matt, for the sake of our audience, the gambit of the arbitration procedure? So how do you start and end an arbitration as the counsel?
Well, as a counsel, when you are approached by your claim, first and foremost, you look through the documents, you look through the case, and you advise your client on the strength and weakness of the matter. Then if there are areas where you're going to concede, rather than dragging it too long, you call the other party and tell them, well, we are the counsel in this matter representing our client. It has done before arbitration. We are ready to meet with you. You meet, and then first of all, those areas where you are ready to concede, you remove that from the issue of dispute. So the narrow issue of dispute that will now go before the arbitrator is what parties will now trash out. And upon appointment, you prepare your statement of your point of claim and get your document. If you're going to use any document, you get your documents ready and make sure that once the process starts, you don't begin to gamble by asking for unnecessary adjournment.
Thank you very much, Ma. So when we talk about the arbitration procedure, issues of first issuing out your notice of arbitration and then commencing the arbitration process, what do you think lawyers can do to ensure that the process runs smoothly? What are the steps they need to take to ensure that the arbitration process runs smoothly?
They have to get conversant to the Arbitration and Conciliation Act, which is the Bible of the arbitration process. Now, when you issue out the arbitration notice, you get to know that it's not going to last indefinitely. And when the arbitral panel has been set up, again, you have to make sure that the parties and arbitrators are on the same panel, on the same page. For example, you at the plenary meeting, the things that you're not going to allow, if you have any objection to the arbitrator, you raise your objection at that stage. You don't wait until the procedure has started before you start to raise objection. If you think at the stage of, if you think that the arbitration is premature, I think at the preliminary meeting, you should raise it, that this arbitration is premature. And in your process, in your point of claim, you could raise it as well, that this arbitration is premature. But if you don't raise it at that time, even if you raise it, remember, even if you raise it that the arbitration is premature, the arbitrator will still want to hear parties, because at the end of the day, What if it is not premature when the documents have been exchanged? Both points of claim and points of defense have been exchanged. And the arbitrator, in his wisdom, has looked at both and said, well, this arbitration, to my mind, is not premature. He directs party to go ahead with the hearing. You call your evidence. But still insists, at the end of the day, you put it in your final written address that this arbitration is premature. You don't insist, for God's sake, that, oh no, your objection, your point of objection must be taken first and foremost. No, not at all. Make sure that the arbitration runs smoothly and fast so that the award can come out, and even the direction on your objection as to whether it is premature or not will come out finally.
Thank you, Ma. Sorry, did you want to say something, Leonard? So.
Oh no, sorry, my attention was distracted.
Okay. Thank you for that. I want you, Ma, to kindly help us identify and describe areas that you see where there could be potential conflicts between arbitration and other ADR.
Areas of conflict. Well, because arbitration can involve parties from diverse jurisdictions, conflict may arise in the areas of choice of law or jurisdiction. Conflict may arise from there. Then, where there is, how do I call this now? Multiple dispute resolution clauses contained in an agreement. It could result in conflict as to which mode of dispute resolution that could be employed. Litigation too, because there is an agreement that I saw recently, about 2-3 days ago. It said where there is dispute between the parties, they can go before the court, and where they are not satisfied, they can come before an arbitrator. And I looked at that agreement, I said, this is funny. By the time you have gone through the court system and you are now coming before the arbitrator, it's a big confusion. So yes, there could be disputes where parties did not state in clear terms the mode of dispute resolution, even though they mentioned arbitration. Where they now come to mention litigation again or other forms of there could be dispute if it's not clearly stated.
Yes, coming to the issue of arbitration once again, like you mentioned, there could be conflicts based on jurisdiction and the likes. Can you kindly take us through possible issues on legal capacity to enter an arbitration agreement, especially when we're talking about jurisdictional issues and we're talking about multi-party arbitrations with parties coming from different parts of the world?
Legal capacity to enter into an agreement, arbitration agreement, where whatever the law does not forbid. For example, criminal transactions cannot be arbitrated upon. And we all know that even the law frowns at criminal transactions. So I think where it is not founded on criminal whatever, parties can enter into an arbitration agreement.
So in other words, if the main subject matter is of a criminal nature, even if the parties have decided to arbitrate, it is still not arbitrable.
It's not arbitrable.
Duly noted, ma. But what if a matter with respect to fraud comes up during the arbitration? What can the arbitrator counsel, as the party to one of the counsel of the parties in the arbitration? What can they do, since you know that yes, these matters are not arbitrable?
I think the part that is not arbitrable can be excised from the part that is arbitrable. The part that is not arbitrable can be excised and taken to a formal court or an appropriate forum for its resolution.
This means that in such circumstances, it's actually possible to have parallel proceedings, one that deals with the arbitration, the commercial matter, and one that
Here it is. It is.
duly noted, ma. Finally, at the end of an arbitration is the award. What are some of the procedures that an award creditor do to ensure that they enjoy the award, especially if the payments, for instance, the damages are not paid?
Sorry, I didn't get that quite clearly. The network here.
Once the yes, ma'am. Once the award has been given, what are the things that the arbitrator counsel can do to ensure that he or her client enjoys the fruits of their award?
Well, this came up recently too. I gave an award and the award creditor came up, I think after about 2 or 3 months, to ask what the case supposed to do. My advice was that the award be registered because it was done in SCC. I said you can register the award with the SCC High Court. And one step you have to register it is to file an action, let SCC High Court adopt it as a judgment. And you now apply to the deputy sheriff to enforce the judgment.
And once the application for enforcement is made, is it possible to also use the normal enforcement procedures as when you have a judgment in court?
Yes, it is. It is, at least that's what they did in this instance. And there's another international arbitration that came. It was registered in the court here, and the deputy sheriff swung into action to enforce it.
And the matter was with, what was the subject area, ma, since it was in the FCT High Court?
I don't get that point. Can you please?
You mentioned Learning Silk, that the award that was rendered was an international award.
So I said there were
and
two.
that it was High Court. Okay, okay.
The other one was an international award. Judgment somewhere, or rather, an award somewhere involved. It was the monetary aspect that we're trying to get, and party was the basis. So what we did was to register the judgment with the court. It was entered as judgment of court, and we applied to the deputy sheriff, who now swung into action. We identified some properties of the award vector, which were attached by the deputy sheriff. For the other one, it was a judgment both in monetary terms and in executory terms. So the monetary aspect was enforced, because I said they should go to court and that the court would enable them to enforce So I think we have done that. For the executory aspect, since it's a construction arbitration, I wouldn't know what they did with that because I didn't follow it.
Thank you very much, Ma. There appears not to be any questions right now for the learned silk. At this point, I would like to say thank you very, very much, Ma. Please do hold on as we call on the next panelist, Mr. Osahon Idemudia, to also take us on this journey of understanding the lawyer's role in the arbitration process, which we commonly refer to as arbitration advocacy. Yes, can you kindly describe to us the powers and the responsibilities of the arbitrator and the role of the arbitrating parties?
Foluke, thank you very much. Good morning to everyone. A very welcome morning in Lagos. So I hope the signals are very clear. A lot of things have been written. Arbitration is no longer in its infancy as it was a few years ago. And a lot has been written about arbitration. That anyone who's truly interested in arbitration and arbitration advocacy serves himself well by investing, first of all, in books, as it were. It's not something you happen into. It's something you take a deliberate decision as to an area of practice you want to actually deepen your roots. In the 80s, late 80s and 90s, early 90s, arbitration was just sort of the new kid on the block. A lot of people looked at arbitration as something that was fresh, but more people took interest in arbitration primarily because it was well resourced in terms of fees, both for the advocates and the arbitrator. So it wasn't developed within our jurisdiction in the way and manner it had evolved in other jurisdictions, particularly in the Western jurisdictions. Arbitration in the West evolved out of business exigencies. Arbitration in Nigeria evolved out of legislative activism, as it were, and a conscious decision not by the business community, but by the legal practitioners to move this resolution in line with what they considered was in tandem with trends in the West, as it were. So in terms of knowledge, in terms of understanding, in terms of custom, in terms of attitude, they're markedly different. So what we find in the situation in Nigeria is that the law was ahead of the custom. The law was ahead of the practice, as it were. And because the law was ahead of the practice, a lot of us then understood arbitration by trying to read up and understand arbitration. Unlike a situation where in the West, where it was a custom that developed, that evolved, of which the law then had to sort of tame the custom and then bring some strictures to make it, to bring it within discernible parameters. So what do you find? You will find a marked difference between arbitration practice or arbitration laws and rules in Nigeria from that of perhaps the UK. It will be said in any arbitration gathering that our rules and laws are way in advance of the practice in the United Kingdom because of the level of limited interference by our courts. Again, our laws are modeled after the UNCITRAL rules, and the UNCITRAL rules were basically championed by United Nations to bring some uniformity to arbitration practice across board and limit the level of domestic interference by domestic courts. The focus, first of all, on international arbitration, then it then tackled down to local practice. So what you find basically is that we have arbitration rules that were practically handed down to us, then the lawyers imbibed it, and then the lawyers handed it down to the businesses, and the businesses imbibed it, and then created an ecosystem, which is our arbitration ecosystem today. Very different from what you have in the West. So there is a distortion in the way and manner we then understand arbitration, because over here, it wasn't championed by the businesses, it was championed by the lawyers. And that is why when people complain about, oh, arbitration is not litigation, the lawyers are trying to make it look like litigation, you need to understand how it evolved. It was created by the lawyers in this jurisdiction. And for the lawyers, they just applied it the way they know how. It was just another of the dispute resolution doors that was open and available to them. So for the lawyers here, that is in Nigeria, it was just a question of which of the doors open to me do I go into? So that's the first thing. So in terms of culture, in terms of understanding, we really do not have we don't well appreciate the nuances between arbitration as a method of dispute resolution and litigation as a method of dispute resolution. It's only just growing and evolving. Number two, the businesses. First of all, Nigeria as not an economic entity, as a place of doing business, is still very much in its infancy. The businesses are not that many. The businesses are not that robust. The businesses are not as sophisticated as you have overseas, the West and the main. So that has had a marked effect, because I had always said, particularly in the 90s, that arbitration had evolved out of some sort of activism by lawyers in insisting that there must be an arbitration clause in every agreement they prepared. And why do the lawyers insist that there must be an arbitration clause in every agreement they prepared? Because the precedent books which they were using always had as clause 19, arbitration clause. So when you're using the precedent book or some precedents to prepare an agreement for a client, or your counterparty is overseas and he sends you the template or whatever he wants with regards to that agreement you're preparing for your local client, there is a clause 19 or a clause 21 or a clause 27 that says dispute resolution arbitration. And it was also an opportunity for us to show off how up to date we were in terms of precedent books, how up to date we were in terms of nuances, commercial nuances, what we brought back from our international conferences. So we inserted it. So every other agreement had an arbitration clause, but both the lawyer and the commercial entity upon which, or before, on behalf of which agreement was prepared, had no idea what that meant. Didn't quite understand the ramification, didn't quite understand what it stood for. So what did you then have was that we had arbitration clauses when disputes came, as it were. There was a clause that says that the dispute should refer to the arbitration. So a client will ask the lawyer, so what do we do? So the lawyer says, let's go to arbitration. Now, if I were the counterparty in such a situation, I didn't want a dispute, as it were, from the beginning, I'm beginning to say to myself, you know what, how do we slow down this process? Maybe we need to buy ourselves time. Maybe we need to do something. So if, for instance, the lawyer on the other side did not perhaps read the agreement, understand the agreement, and files an application in court asking for interim preservative orders or whatever it might be, it then becomes a very easy way to slow down the process by filing a preliminary objection and says, oh yeah, it has an arbitration clause. So I am indulging or engaging the court, not because I'm interested in resolving the disputes, but I'm taking advantage of a technical provision in a commercial understanding to slow down the dispute resolution of the other side as much as I can to the advantage of my clients. Now, people must understand that basically, while lawyers are subject to ethical prescriptions and constrictions, nothing stops you from taking advantage of what the law allows you to. Because a lot of times we just say, is that right? Is that not right? Courts and disputes are not about morality. It's about the law and the clear prescriptions of the law. So the first thing you must know as a lawyer when you're dealing with a commercial agreement or a commercial dispute you must have a working knowledge of the facts, the agreement, the background and co. Then you must have a working knowledge of the law. Every dispute is about competing narratives. Every single dispute is about competing narratives. How do you stack up the facts? How do the facts so stacked up reflect, or how does the law reflect along the line of the facts so stacked up? So when sometimes people talk about the morality of a case, to my mind, you're very wrong. Because your idea of the morality of the case is dependent on how you stacked up your facts. And if I restack those facts along my own lines, the morality you're standing upon will lose its credence, and perhaps a new set of morality will come to play. So in other words, you must know the facts, first of all, of the disputes. Understand the disputes like you are the party, and perhaps much better than the party. Secondly, understand the law and the full gamut of the law that surrounds it, ever before you give any form of advice, as it were. And if it does have an arbitration clause, then you ask yourself a very simple question. Mrs. Adesina is here and did point out, did make a point about technicalities, about the lawyers being trained brickbats and trying to slow things down. But one fact that cannot be overlooked is that a lawyer who decides to rely on technicalities is well within his rights to do that. If the facts and the law allows him to be technical, by all means, why can't he be technical? The lawyer is not there to actually resolve the dispute. The lawyer is actually there to see through his client's cause. And if his client's cause is best served with the technical aspects of the law, by all means, I will do just that. So you need to understand the narrative you want to place before, or the narrative you want your client to hold on to. Now, in understanding the narrative your client wants to hold on to, you want to also understand what is your client's end goal. What does your client want? I've had, and in the course of my conversation with the audience, I probably referred once or twice to an interesting matter I had. It was an international arbitration. And as often is the case, the counterparty were foreign multinational, as our client was a local company. So the cost of arbitration, first of all, was onerous. It was an ICC arbitration. So the starting cost ran into about $250,000. Then the arbitration clause had 3 arbitrators. So where do you start from? From the beginning, your client who has a financial first of all needs a particular case. We were actually the defendants. The other side had so they went to the ICC. They had already put the money down by 150. We had the money to put, but the ICC would insist that all the money be put down for you. So the claimant was only actually to give them a commercial advantage over our client in the commercial sense. So it wasn't looking for altruistic values as to morality, as to right to wrong. It was just a commercial advantage of the other. So and part of it was to make sure that the arbitration which they had commenced and which the contract allowed them to commence is slowed down as much as possible. And if need be, if the process allowed it or the laws allowed it, abort it. And so that is what we did. And how did we go about it? When the arbitrators, we had no problem agreeing to the arbitrators, but then under the ICC rules, you must have terms of reference. And most institutional arbitrations have now incorporated that into their rules. And sometimes actually encourage it in ad hoc arbitration. So terms of reference. Now, with regards to the terms of reference was drawn up and all the parties were supposed to sign, and then I just objected to the terms of reference. I objected that the terms of reference was drawn up because I submitted, it exceeded A, the dispute clause in the arbitration clause, and B, the notice of arbitration vis-a-vis what was in dispute. The arbitrator, I remember on one occasion, the lead arbitrator wrote and said, well, he's going to impose it on us. And I said, oh, no, you can't. Because arbitration is basically party driven. And we insisted why that could not form the terms of arbitration as well, the terms of reference. 6 months, as it were. And the ICC just kept extending time by additional 3 months for parties to agree on the TRO. And we never did. And I think after about 12 months or 18 months, the counterparty got tired, reached out to my clients, they met, and the matter was resolved. And the ICC was informed that parties had reached an understanding and that they then desired to withdraw the arbitration. And it was one of the understandings between the parties that whatever the cost of arbitration that they had initiated, they would solely bear. So what am I trying to say? Number one, know the facts, know the law, know the cost your client wants. Now, because arbitration is now so extensive, it's gone beyond its initial models, which was just commercial disputes. It has taken slight variations and is now sort of hydro-headed. But one of your responsibilities as a legal practitioner when you're faced with a potential arbitration dispute is know what the facts are, understand the law within the realm of those facts, and understand the costs that your client is trying to urge. Your responsibility as an advocate is to urge your client's cause within the confines of the law. Remember, in most cases, they are commercial disputes. It's not a matter of who wins or who loses. It's what is in your client's best commercial interests. So that is the first thing you want to think about. The second thing is, in then initiating the process or defending the process, the critical point is how you commence it, your notice of arbitration. I had a matter that I had done a local arbitration, even though the local counterparty was a multinational, but a local subsidiary. And the first objection they took was to our notice of arbitration. And they had taken the objection on the ground that the notice of arbitration was not in conformity with the provisions of the articles attached to the Arbitration and Conciliation Act. Interestingly, the Institute was the appointing authority with regards to that arbitration. Now, when it took that objection, I do remember my colleague and I reviewing it, asking ourselves two things. A, we could withdraw the arbitration, discontinue, pay the cost, and do it again. Or B, allow the arbitrator resolve the issue whether or not the notice was adequately served. Why? Because it bordered on jurisdiction, and our law leaves the issue of jurisdiction firmly in the hand of the arbitrator. So we took a business decision. Let's take it before the arbitrator. Now, we were in a hurry. We needed the arbitration to go on. And we realized that if we had to now go back, it was going to cost us time and all of that. And again, and that's just human nature. We're also very confident that it's very difficult to get an arbitrator who will rule on a preliminary objection on jurisdiction and say that he or she or the tribunal doesn't have jurisdiction. You've just limited your earning fees, your earning power. So I can tell you that over and over again, you take a preliminary objection before an arbitrator and tell the arbitrator he has no powers, the arbitrator is never going to rule in your favor. And it's just commercial sense. The arbitrator is there not on national duty like a judge. The arbitrator is there on a commercial duty. So he's going to look at his own commercial interest. So as an advocate, just bear that in mind, as it were, to know how you go about it. So we took it before the arbitrator ruled that there was jurisdiction, other pleadings, and trial went on, trial opened. If you ask me with the benefit of hindsight, what was a mistake we should have done in TOR? Now, what would the terms of reference have done in that particular instance? The terms of reference could have delimited or would have reiterated what both sides agreed to be the issues and disputes. And then it would have actually agreed that both sides had acquiesced to the appointment of the arbitrator in question, as it were, and then both sides would have signed on it. So technically, what would have happened was that the TOR would then satisfy the provisions of Section 1 of the Arbitration Act, which says that an arbitration can be enabled when both parties agree in writing or in their pleadings as to arbitration. So the issue of jurisdiction that could then be raised subsequently is completely obviated. So it was not the purpose for which the TRO was actually thought of, but it serves that additional purpose of reinforcing the jurisdiction of the arbitral tribunal. If you as an advocate, you want to be sure nothing goes wrong. But if you don't want to actually cover that particular base so that you leave that room open to you for subsequent challenges, should that need arise, then you don't have to resist. But I will always advise and insist that is TRO terms of reference is signed by all the parties and the arbitrator, because that reinforces the issue of jurisdiction. And then if there be anything wrong with regards to the notice of arbitration, or they define the limits of the arbitration tribunal, then that will cure it. Now, let me just, because you asked me a question as to the powers of a tribunal. Now, I want to read a passage from the book, International Commercial Arbitration, Alan Redfern and Martin Hunter, one of the early editions. Chapter 257, the chapter that deals with the powers of arbitration. It says the powers of an arbitration tribunal are those conferred upon it by the parties. Can you hear me? Can you hear me?
Yes, sir. I was going to say that the book you were referencing is practically the grand norm of international arbitration.
Okay, that's why I said, I'm reading from one of the early editions. I know they have all sorts of, I always say, you have anything particular with international arbitration, please refer to the book and try and understand it. But he says something very interesting here. The powers of an arbitral tribunal are those conferred upon it by the parties themselves within the limit allowed by the applicable law. Then he explains, mark the word here, says by the parties themselves. Then he goes on to say, together with any additional powers which may be conferred by operation of law. In principle, these powers should be sufficient for the arbitral tribunal to carry out the tasks properly and effectively. It is well contained in a well-conducted international commercial arbitration. Control of the proceeding moves gradually from the parties themselves to the arbitral tribunal. So it is the parties who actually have the powers, then create the powers for the tribunal, and then slowly cede powers to the tribunal, which the tribunal exercises over the parties and over counsel in the conduct and the resolution of the dispute. So you as an advocate will start from the beginning by asking yourself, how much powers do I want to cede? Now, sometimes when you have a counterpart, colleague on the other side, who's also extremely circumspect about the tribunal or about the arbitrator, then both of you can decide, you know what, we do not want the arbitration. Why is it important? Because a lot of lawyers do not understand that the limits of the adjudicating powers of an arbitration tribunal are limited by the powers donated to the tribunal by the parties. Unlike in the national court, it doesn't have unlimited jurisdiction. So because it doesn't have unlimited jurisdiction, it must confine itself to the powers donated to it. And I'll read some further extracts to help drive that point home. So that being the case, you want to be extremely careful as counsel how much you are allowing A, the tribunal, B, the other side. Now, why does that become very crucial? If you have the single fortune of having on the other side in an arbitration dispute, counsel that having done his homework have an issue, either in the way he had drafted his notice of arbitration or in the way he signed the TOR, then he just gives you a latitude to upend whatever dispute he had actually submitted or intended to submit. Because bear in mind that at the point where the notice of arbitration and the TRO are signed, the pleadings have not been called in. Because only after the TRO are signed, in most cases, that you call in for the pleadings. Now, it is when the pleadings are called, the points of claim, the points of defense and co, that parties sometimes become fully aware of why perhaps the defendant was resisting whatever the claim or whatever the demand the claimant was making, or the defendant becomes more aware of really what the claimant was pushing for. And at that point in time, as it were, he wants to use the pleadings to now cover the grounds. So for the advocate, again, if I were defense counsel in the proceedings, that is where I'm just going to make sure you can come in. Why? Because we have delimited the jurisdiction of the tribunal vis-a-vis the notice of arbitration and then the TOR. Now, bear in mind that the arbitration tribunal doesn't have an unlimited jurisdiction, and therefore cannot just assume anything that crops up or pick up along the line collateral issues that now arise for this, that now appear to be germane. So when you are actually zeroing in either on your notice of arbitration in spelling out what the issues and difference are, or the terms of reference, as defense counsel who doesn't want the claimant to get in, make it as restrictive as possible. As claimant counsel, that you know that something might come up that you want to let in, you make it as broad as possible. So that when issues, then collateral issues arise, you can actually then fit them in. So once you have been able to understand your client's costs, know what your client wants, then in the commencement of the arbitration, that becomes your primary focus. Then also do not forget that the way and manner the arbitration clause is drafted is extremely key as to the latitude in terms of jurisdiction the arbitration tribunal will assume. Now, it is very rare that the counsel in the dispute were ever involved in drawing up the commercial agreement or the arbitration clause. It's always very rare because sometimes those disputes do not arise until some years later. And particularly, again, if you practice in our client, the people who draw up the agreements never actually do commercial disputes, whether in the courts or otherwise. So you have that sort of dichotomy. So you as the advocate make sure you look at the clause. Now, if the arbitration clause has is seen as too restrictive, and you want it expanded, then you must understand that you can't expand it with your notice of arbitration, but you can expand it in the TOR, because Section 1 and I guess Section 2 of the Arbitration Act that says every arbitration agreement should be in writing. Then 1C says in exchange of the pleadings in reference in a contract, as it were. So you hide under, so you use a TOR to expand the jurisdiction of the tribunal potentially far wider than what the arbitration clause in the agreement allows you, in hiding under 1C. Now, what are the powers and responsibilities of an arbitral tribunal? The powers and responsibilities of the arbitral tribunal are basically, if you ask me succinctly in one word or in one sentence, resolve the disputes that have been submitted for adjudication. Now, how does the dispute get resolved? Within the parameters set by the parties. Now, in saying this, I must then add, when you're dealing with institutional arbitration, it's a slightly different. So when you put in your dispute resolution clause or your arbitration clause that disputes will be resolved in accordance with the rules of the institute, and if the institute has existing arbitration rules, or the ICC, or the London court, or the Lagos court, or whatever, it means that you're subjugating that clause to the extensive provisions in the rules of engagement by those institutes. So before you engage, make sure you understand what the rules of those institutes say. Then if you're, for instance, engaging, let's say the London Court of Arbitration, as an example, you will see a further clause that says that with regards to evidential matters, the IVBA rules with regards to evidence and all of that shall apply. So it's important that you read those rules in details and all the further referrals it shall give you, so that you fully understand the full gamut. In ad hoc arbitration, in arbitration matters that come under the Arbitration and Conciliation Act, your powers as parties in delimiting the jurisdiction of the arbitration tribunal is not really fettered or limited. It just depends on how you as an advocate can actually convince the other side or lead the other side to come to terms as you want it or as it favors you, as it were. There's nothing altruistic about it. I don't have to be fair or be balanced. I lean towards the person who's paying my fees and towards achieving the cost in question, all within the context of the law and the rules that govern the dispute, so to speak. So with regards to the powers, let me just read again from Redfern. It says the parties may confer powers for those who will care. It's I'm reading from second edition, page 258. The parties may confer powers upon the arbitral tribunal directly or indirectly, but only within the limits of the relevant law. So it's the parties that actually confer the powers. Now it says, at first, it's the parties who are in full charge. They alone know the issues in dispute, how they intend to set about proving the facts upon which they place reliance, and what arguments of law they propose to put forward. The arbitral tribunal owes its existence to the parties. It is their arbitral tribunal. So that is really the marked difference between an arbitral tribunal and a national court. A national court has unlimited jurisdictions. Issues can arise, as it were, that are subsumable under the main issues and can be termed collateral issues, and they can attend to it. What they can attend to are those issues that are clearly not submitted for resolution before the national court. But in arbitration, the powers are not so wide. The times where they may be wide is when they're institutional arbitration, where the rules of that institute allows the tribunal appointed by the institute to deal with the collateral matters that can actually be deemed to have arisen out of the main matters. And then, again, something that has become topical in the last few years, the parties that might be subsumed under the dispute or that could then become bound by the final resolution. Quite a lot of arguments about, but since the Dow Jones case by the ICC in France, the issues of related parties have become more prominent. In other words, if there's an arbitration dispute between two parties, one of which is a subsidiary or a part of a group of related parties, it's now sort of looked at that the arbitral tribunal can assume jurisdiction over the party before it and all the other related parties, as it were. So you need to be very careful. If you do not want the related parties to be subsumed into the dispute or be bound by the outcome of the dispute, then you want to be sure in your terms of reference to make it explicitly clear that this reference relates to only the parties before it, and the finding of the tribunal shall not be binding, as it were, to any other party, related or otherwise. Now, these are things that are extremely important as counsel when you are conceiving a dispute, you are approaching a dispute, and you want to make sure that you're not blindsided or your client is not caught off guard. And I don't know if I'm still within my time limit, just to remind me how much time I have. I am. Okay.
You are, but I was going to ask a question just to ensure that we have
Okay.
we were able to tie all of this together. So from what you have said, sir, you've gone extensively talking about how the mentality on arbitration in the business space in Nigeria is part of the reasons why some of the challenges that we are seeing in the space are coming up, because it didn't grow indigenously. It grew by reason of external influence, pretty much like the way English law has then essentially given birth to common law and the system of laws in Nigeria. The other aspect of it, however, and I know that we're now getting into the technical aspects of arbitration advocacy, is with this use of terms of reference. And there's been a question there already. There are some questions I'll probably leave till after all speakers have spoken so that there can be more time to discuss them. However, I would like to ask, as a follow-on to my previous question on the responsibilities of the arbitral tribunal and of course that of the parties you have explained in the light of the arbitrator advocates, how do you select your arbitral tribunal?
Good question. In the United States, for instance, let me just sort of give you a corollary, where a trial by jury is still very much the norm. Jury selection is a skill set in its own. You get the jury right, you're probably going to be able to push your cause through. So you have people who are trained to do jury selection and all of that. So how do I select my arbitration? Now, I'm speaking as an advocate. I'm always more comfortable acting as counsel in an arbitration than being an arbitrator. So I say to myself, how do I push my cause? So a lot of arbitrators don't like this. But when I'm picking an arbitrator, I try to look for that arbitrator who's not a professional arbitrator, depending on who my client is. What does that mean? The professional arbitrator is someone who earns his living from arbitration practice, market. Then I look at who's the counterparty on the other side. Now, if it's a large firm or it's a firm that has a constant supply of arbitration matters in the supply chain, as it were, then I say to myself, if I settle for a professional arbitrator who perhaps enjoys the patronage and constant nomination from this big supply of arbitration disputes, then I'm going to start this by swimming against the tide. So what will I do? I will rather look for my first choice, if it's a sole arbitrator, is an arbitrator, because again, the law does not say an arbitrator must have any form of qualification, who has sufficient sustenance outside just being a professional arbitrator. That gives me, as Osahon Idemudia, a lot of peace of mind. Number two, I'm looking for that arbitrator who's not necessarily knowledgeable in the law, but who is sufficiently independent-minded to be able to hold up a scale and then check for the balance. If I get an arbitrator who is extremely knowledgeable in the law, I'm going to have an argument every single step of the way as to whether the law is right or wrong on the points. Now, always remember that arbitration was never designed for lawyers. Arbitration was originated by people who were moving away from lawyers, the courts, and the law. It was originated by mariners who wanted to quickly resolve disputes by somebody who they could trust, who they felt was fair-minded, who was available or known to them, and who, if he heard what the issues were and reached a decision, he was trusted to be unbiased, fair-minded, and would exhibit sense, common sense that is in consonance with the area within which the dispute was. So that is the kind of person I would look for. So if I have a dispute that has to do with building construction, for instance, or architectural design, I'm not going to look for a lawyer. I'm going to look for that architect, that quantity surveyor, that engineer who has a broad mind, who is sufficiently endowed or believes enough in himself and will be fair-minded. Now, sometimes your clients will lean on you and say, oh, because it was Foluke who was counsel on the other side who nominated Mr. Agbola as arbitrator, I should naturally oppose and go and nominate mine when I know that Mr. Agbola who's been nominated ticks all the boxes that I'm looking for. So you must first of all have a clear idea of the kind of arbitrator you want, vis-a-vis the disparity, stack up your facts to his appreciation. So if the other party picks somebody who ticks all this, by all means, do not just contend for it, become contentious for the sake of being contentious. Take it. Now, as a rule, I'm not a fan of 3-panel tribunals. Again, why it's not cost effective? I am collecting a fee as counsel, and suddenly your client has to pay 3 other people perhaps more than he's paying you. So your earning power sufficiently diminishes. So even where the provision in the arbitration clause is you can have a 3-panel arbitration panel, both sides can actually agree to limit it to 1. As long as it's in writing, it overrides. It's just innovation. But in such instances, make sure your parties sign. Even though you as counsel can bind, it can be argued that whether your level of bindiness is with regards to things that are active in court, or can you actually bind your client in a contract when the client has not given you that authority? I would say you can't. So make sure the parties sign along with counsel in limiting it. So those are 2 things. Of course, there are a few other things you will look at in where's the seat of arbitration, as it were. So
That's
once you know where the seat of
international.
arbitration is, local, well, thank God for Zoom now. These days, when it's international, you really can sit in Lagos and the arbitrators can come from all over the place. So
That's true.
again, always make sure that that latitude is allowed. Allow that electronic thing, because if your counterparty is a multinational and like we inadvertently always do, the seat of arbitration is in London or somewhere in Europe, your client is already minus $50,000 in share logistics without your fees in initiating the process or commencing the process. And the more cost and expense your client has to bear, the less enthusiastic he is about the whole process. I had a client once where we had a commercial dispute around an oil block. And the counterparty was a Chinese company. And it was a decision arbitration ICC. So by the time we sent the notice of arbitration and all of that, the Chinese company didn't answer. So we sent it in the ICC. The ICC nominated arbitrators, and the ICC asked us to make a deposit of £300,000 each, $300,000 each. And so the client asked me, if I pay this $300,000, since these guys haven't answered, what will happen next? I said, well, we will have to pay their own $300,000 before we can take the next step and pay $150,000 as administrative fees, as it were. And he said, okay, we are now knocking at about $750,000. And he says, will this be the final? I said, well, depending on how things proceed, they may ask for a top-up. And he said, you know what? Just write to the ICC and tell them they are very unfair to businesses in the third world. And that this is not right. That he didn't realize this is how the ICC runs. He would never have agreed to this kind of clause and co. That's why I said it wasn't the businesses that have been in the forefront of arbitration. A lot of businesses don't understand it. Sometimes the matrix itself is not favorable to them. So without much ado, with regard to that particular arbitration, it was abandoned. Yes, he had a good claim, but the sheer magnitude of what he had to lay out. And I did also have a local dispute where, and this was within one of the institutional arbitration centers in Lagos, where we had to put a deposit of $300,000. And again, in that instance, the client looked at it and said, you know what, I'd rather go to Abuja and discuss with the people who are holding my money. If I give them $300,000, as it were, what is the guarantee? And those are the realities. So those are some of the things. The seat of arbitration is extremely key in your choice of arbitration. The number of arbitrators, I will always settle for a sole arbitrator, as it were. Now, sadly and unfortunately, in our client, wrongly though, but that is what it is, arbitration is seen as a court of first instance, of which there are 3 other courts, as it were, which then makes the whole thing very cumbersome, unattractive, and all of that. So it's up to you in deciding in your choice of arbitration or your choice of arbitrator that you have one who will be less verbose in terms of his approach to the issues, because what the arbitrator is asked to do is reach a decision between 2 competing narratives as to which one you believe, not give lectures on laws. In fact, the power of the arbitrator is so profound that he can reach decisions on issues of fact, and in Nigeria, on issues of law. And whether his decision on point of law is actually right or wrong, you are bound by it. So the less you have to say, the better as an arbitrator. So you as counsel, you're looking for that arbitrator who's not ego-driven. You're looking for that arbitrator who's not a know-all person. And you're also looking for that arbitrator who will have the time. So as counsel, keep it simple. The truth of the matter is you really do not need to have a legal practitioner representing you. It is wise, it is expedient, but it's not compulsory. So bearing that in mind, keep the issues simple as possible, so that the arbitrator can keep his award simple. So that will be my practical guide to choosing an arbitrator.
Oh, an arbitral tribunal. Thank you very much, sir, for that very interesting expatiation on on how to appoint the arbitral tribunal. I know that one of the things that I commonly get asked, even by colleagues, is where do you start? Okay, my client has brought this notice of arbitration. What's the next step? And really understanding how to appoint the arbitral tribunal or the arbitrator, as the case may be, goes a long way in even ensuring that you have a case that you don't end up abandoning, or you don't end up tangled in the web of technicalities. And like you rightly mentioned, unfortunately, in our clients, it has become the first step in a series of steps, which unfortunately makes Nigeria look like a destination that is not great for international arbitration, which ironically overshadows the fact that many of the arbitral awards are actually upheld by our courts. But because of the amount of time it takes there, justice delayed, they say, is justice denied. Thank you once again, sir. We're still going to come back to you for some questions. There are questions in the question and answer box, but at this point in time, I would like to call upon, you're welcome, sir. I would like to call upon Mr. Adeleke, or Chief Adeleke Agbola, Senior Advocate of Nigeria, Fellow of the Nigerian Institute of Chartered Arbitrators. Yes, sir. My very first question is, so now we're going to go into the meat of the work itself. So my first question is, what are the filings that needs to be done from the place of the arbitration agreement to the notice of arbitration all the way to the arbitration award, sir? What are the key filings? Yes, sir.
Yes, thank you for that. And I don't know about your area. It's raining cat and dust here, so I can hardly hear myself. So I hope. Okay, yes. The most important filing, of course, in where you are involved in as a counsel in arbitration proceedings is the notice of arbitration, which identify the disputes, identify the agreements that is the basis of the arbitration agreement, and a case where there is no mention of that of an arbitration clause in the agreement between the parties. Perhaps parties can at any time agree to go to arbitration. Sometimes it's based on court referral. So once you file your notice of arbitration, of course, the next thing is for the appointment of the arbitrator. And sometimes, depending on the nature of the case of the claim, you may file your point of claim together with your notice of arbitration, or wait for the plenary meetings where the arbitrators will give directives as to how parties are to exchange their pleadings as it were. So you have the point of claim, you have the point of defense, and you have the reply. So once all those things are in, you have got all your papers right. Nowadays, because people are simplifying the appeal process, you can even have a statement on oath of your proposed witnesses, and you can also front load all your documents, depending on what you have agreed at the plenary hearings. As rightly pointed out by my very good friend Osahon earlier, arbitration is party driven, so the parties can agree on the mode, how they want to do it. But sometimes it can be document only. You can agree that the arbitration will be by document only. You do not call witnesses, you just submit the documents. It can be a mixture of both oral hearing and documents. Sometimes arbitration can be done by just simply inspecting the locus in code by the arbitrator and send to inspect and find out who is at fault and who is not at fault. So there is no strict and formal way as to how you conduct arbitration. It depends on what the parties have agreed. But of course, the most important thing is the initiating process, which is also arbitration. And because when it comes to determining when arbitration process starts, it starts for the date when the notice of arbitration is served on the other party. That can be very, very crucial in determining the issue of limitation period. But once you have served notice of arbitration, the arbitration has commenced. All the other steps are just steps in it. So we have seen I have been involved in a matter where the arbitration hearing itself started about 12 years after the notice of arbitration was issued. And when it was raised as an issue, the arbitrator rules that arbitration commenced from the date notice of arbitration is served. So those are the papers you need to file. Notice of arbitration, point of claim, point of defense, response to the point of claim, venue, and depending on how you want to conduct it. If it is by oral evidence, you call your witnesses. If you can, it's only document, you can just go about it by that way. So those are the documents you need. Is that okay?
Yes, sir. So take yeah, not a problem, sir. So taking it from the documents that we're going to file, sir, the very first of it, of course, if there isn't an arbitration agreement, you don't even have an arbitration to start with. What are the key considerations that the council should have in drafting an arbitration agreement?
In drafting arbitration clause, of course, you have to be very, for arbitration matters, the clauses, the way you frame the arbitration clause will determine whether you are going to have a single arbitrator or a three-man arbitrator, arbitration panel, the locus, the seat of the arbitration, the venue, all those ones can be taken care of. The properly drafted arbitration clause will have taken all those issues. You are taking care of all those issues because you see a lot of very vague arbitration clause that allows for causes so much delay in the commencement of the arbitration process. But a well-drafted arbitration clause, a lot of the institutions, like our own institute now, the Nigerian Institute of Chartered Arbitrators, has a model arbitration clause that states straight away what is the rules that will be used in the arbitration, what is the law that will be used, what will be the venue of the arbitration. So those are arbitration clauses, but don't forget a lot of parties to a contract just lift arbitration clause from one they have seen in the past, without any reference whether it is useful for their own particular purpose. But once there's arbitration clause, yes, you can have arbitration that can go on that basis, but it makes the job of the arbitrator itself a bit more cumbersome because if you have to rule on where is going to be the seat of the arbitration, where is going to be the venue, what law is going to be the basis of the arbitration, all those ones can be taken care of in a properly drafted arbitration clause. And don't forget, some of us, we act not only as lawyers, we also act as arbitrators. So it helps us when we have a properly drafted arbitration agreement to know exactly what is the limits or the powers of the arbitrator. Thank you.
Thank you, sir. So with respect, so once the arbitration clause is drafted, whether it is pre or post the dispute now arises, and then the counsel to the party that is initiating the proceedings has to file their notice of arbitration. So what are the main items to be listed out in the notice of arbitration, sir?
Yes, once you are drafting your notice of arbitration, because notice of arbitration is to give notice to the other party that there's a dispute. So you have to start with to state the agreement between the parties. You state the agreement between the parties. That is, oh, is it a bidding contract? Is it a consultancy agreement? It can be, I mean, arbitration clauses cover so many areas. So you have agreed, so you have to state it that, okay, pursuant to the agreement between us in respect to social, which is purely simple. And then you go to the issue of the dispute between the parties, what has led to the dispute, or what is in contention between the parties. It has to be stated. And of course, in that arbitration agreement, in that mutual arbitration, you need to state the particular clause of the agreement between the parties that contains the arbitration clause. As a matter of fact, it's standard that you lift and paste that particular clause, arbitration clause. But that is what that gives jurisdiction to the arbitration panel. And once you have done that, you now state what reliefs you'll be asking for. And then sometimes if it is one that says parties shall nominate arbitrators, you proceed to nominate your own arbitrator. If it's a 3-man panel, for example, you may nominate your arbitrator and ask the other party to nominate his own. If it's going to be a single arbitrator to be appointed by consent of the parties, then you propose your own list of arbitrators, and you give a timeline within which the respondent should refer back to you. Otherwise, if the agreement makes alternative, because if, for example, you are supposed to appoint a single arbitrator, you propose, and the other party simply ignore your proposal, which happens a lot of times, you'll be surprised to know. You may then have to go and see what is there alternative appointer. For example, I know standard, you may say, oh, if the parties cannot agree, then the president of the Nigerian Social Arbitration should appoint. So you write a letter to you have to write a letter to that appointing authority. It may be the chief judge of Lagos State, it may be the sometimes, although I will not do that now because that will be taken too far. The chief justice of Nigeria, that if you cannot appoint, if you are not able to agree. So those are the clauses you have to put there in your notice of arbitration, so that it can, anybody looking at it will know that you are. This is not a joking matter. This is a serious matter. So if you have put all those ones, then you sign it and send it to the other party. That is the commencement of the arbitration process. Thank you.
Thank you, sir. So now we've done the notice of arbitration. The other party does not respond. What steps can the council take? And if the other party responds, what steps does the council to the claimant take?
Now, let us take the first scenario, which I've mentioned in passing before. If the other party does not respond, it now depends on how well you have drafted your arbitration clause. If it's a properly drafted arbitration clause, you have anticipated that if you do not respond, if the parties are unable to agree on arbitrator, then there will be a third party to be appointed, independent, to be appointed, to be the appointing authority. And whoever that third party chooses, if there's no conflict, is the person that will be the arbitrator. The alternative, if you do not put an appointing authority in case of non-agreement between the parties, then you have to go the long way. Then you have to make an application under the ACA to the court for the court to appoint an arbitrator for you. Now, I can assure you that is not something you want to do under the present climate in Nigeria, where every little thing gets delayed in the court. So that's why I join litigants, especially their lawyers, when they are preparing the agreement to agree on somebody who both of them have confidence in, to be the authority to appoint if they cannot agree. Now, the other scenario is that the other party responds, and I have listed Mr. A, Mr. B, and Mr. C as my proposed arbitrator, and the other party responds, so I don't want any of those ones. it nominates its own, give a fresh slate of nominees. If both parties can come to terms and they agree on one person in that, of course, that is the end of it all. But if not, then the other scenario still applies. So you have to appoint that, because that is the beginning of the whole show. Because without the arbiters being appointed, the arbiter cannot be kickstarted. So once, whatever way it is resolved, you may have to go to court to even get the arbiter appointed. You have to get the arbiter in place. So once the arbiter is in place, if it's a single arbitrator, but if it is not a single arbitrator, if it's a 3-man panel, that one is a little bit easier. Both parties appoint their own arbitrators, and the 2 arbitrators now will agree to pick their own, the presiding arbitrator. So it is the party appointed arbitrators that will appoint the presiding, and the position of the presiding is so powerful. Mr. Osahon said before that he doesn't like a 3-man panel because of the cost issue. But sometimes you have no choice in that matter. If that is what the agreement provides, or in a complex arbitration where what is an issue is massive. Sometimes I've recently somebody introduced, wants to appoint me arbitration in a matter of 20-something million naira. And it's going to be a 3-man panel. I said, how much will the arbitration fee be for 3 members panel for a recovery of less, just about 20-something million? But if that's what the parties agree, they can always find a way to do it. So you have appointed arbitrators, whether 1-man panel, whether it's a sole arbitrator or a 3-man panel. Don't forget, if you don't stipulate in your agreement as to the number of arbitrators, then you have to go to the default position in the ACA, which is 3-man panel. So that is another reason why we must have a very tight agreement. So once the arbitrator is appointed and is contacted, it's the duty of the arbitrator to find out who are the parties on both sides, and to indicate whether it's in conflict. Because it is the responsibility of the arbitrator to be clear to the parties whether he has conflict that will affect his impartiality in the matter. It is not because you know one lawyer for one side or one lawyer, no. The issues now is more of the parties. Is there any reason why you're not able to do justice to the parties? Those are issues of conflict that can be resolved at the first meeting. So that is at that stage, once the arbiter has resolved that there's no conflict and none of the parties has objected to his appointment, because when you look at the arbitrator, you get his profile, you look at what cases he has done, you may object. The parties are at liberty to object, but don't forget the arbitrator is to rule on that objection. It's not something you take outside. You have to first file it before the arbitrator. It's only if you cannot resolve it or you are not satisfied, you may then go for review. So we have gotten to the stage of the arbitrator is now in place. Madam Moderator.
Thank you, sir. So now we've moved from the arbitration agreement to the notice of arbitration. And so you've already actually moved into the preliminary meeting, which is the first meeting between the arbitrators and the parties. Now, sir, after the preliminary meeting, what are the documents that will be produced by the tribunal, and what should be the responses from the council in terms of their findings?
The preliminary meeting, which I've mentioned in passing, is a very important step in the arbitration process, because a well-conducted preliminary meeting reduces the time spent in conducting arbitration, because a lot of issues that causes trouble can be resolved at that plenary meeting. And plenary meeting does not mean that you finish it in a day. Sometimes plenary meeting can drag on for 2-3 days because of if it's a complex arbitration. Because you have to determine how are you going to conduct the arbitration. Because I will always ask, what kind of arbitration do you want? Because it is party driven. You want us to have a blue, because a lot of default position of most lawyers is that they want to do it as if they are in the high court. They want as if they are conducting a trial. That doesn't necessarily mean it doesn't have to be so. So you can have a situation where parties agree that we are going to have documents only. That, oh, this thing doesn't require, just for you to interpret the document for us. We will submit our documents to you, and we submit our written addresses on the issue of law, race, or whatever. And that will be all. So, or you can also agree, oh, we are going to have a registrar for this tribunal. We are going to have clerks. Oh, we are going to have experts. We are going to have assessors to assist the arbitrator. All those things are issues that must be submitted, must be agreed upon. How many days do you need to draft? If no point of claim has been submitted before, how many days do you need to submit it? Point of defense, how many days do you need to submit it? When you have resolved all those issues, the arbitrator will be in a position to evaluate how long the arbitration will take. And then it goes to the issues that is always paramount to arbitrator, his own fees. He has to now determine that, okay, based on this issue, on the amount of days parties have agreed this matter will take, the number of exhibits, the number of witnesses, expert evidence, payments, where are we going to have, where is going to be the venue for this arbitration? Are we going to Marriott Hotel, or are we going to Intercontinental? Or are we using my conference room? All those issues will affect cost. And in my earlier years in arbitration, I went to arbitration, I saw food, and I refused to eat. But I said, the Coke, I refused to take anything. I said, I'm here just to focus. And in the end, when we finished, I got a bill from the arbitrator for the cost of food served. I said, but I didn't take anything. I said, well, it was there, you didn't take it. So those are practicalities.
It was part of the administrative costs.
Yes, definitely. So it's important. And I remember I did one matter before the late Honorable Justice Thomas in 1993 or so, arbitration. He just retired at that time. And he said, oh, sir, how much are we going to pay? So just make a deposit of 100,000 naira. So he was not committed. He didn't commit to set a particular figure. He just said, make a deposit. And when we got to a middle stage, when we closed our case and the defense was open, so come and pay. He asked us to pay 400,000 naira each in 1994. So that should give you an idea. So now with that experience, I always insist, I want to know what is the fees of the arbitrator before we move too much. Because those are the issues that can cause friction. Then don't forget, you can negotiate the fees. If it's an institutional arbitration where the fees are already, you can look at the brochure of NICArb. There's a suggested fee. But even that one, people still vary it. All those issues should be taken care of at the plenary hearings. And it is those ones that will tell you what documents you are going to do. If you are doing international arbitration, it's a little bit more complex than the local arbitration we are doing here. Because when you do international arbitration, discovery is a very vital aspect of international arbitration, which we take very little, we hardly use it here. But discovery is very important in international arbitration. Your relevance, your response, and with all due respect, Oyibo man is very, very truthful when it comes to discovery. Because we say, I want to see all the emails that has come between internal emails, not even the one between the parties, internal emails of one party to determine what are they saying. You can see the matter that was just, even a trial that was just concluded last week in US in respect of the Dominion voting system. It was discovery that finished the case, because it was in place of discovery that all the internal emails of Force Corporation were discovered, and that makes the case going to trial untenable. So those are the issues that can be discussed at the plenary hearings, and will determine what the documents that we find. Thank you.
Thank you, sir. So the documents have been filed. The next stage will be the hearing proper. At this point, of course, parties have exchanged pleadings. So, sir, how do you prepare an effective legal argument if it's an arbitration that requires the address on issues of law? maybe legal claims. How does a counsel prepare for such? And here we are assuming that it's an oral hearing for the sake of advocacy. How does counsel prepare for such a hearing, both written and oral arguments?
I happen to know that there are people on this platform today, and there are members, fellows that are not even lawyers. So don't let us look at it from the legal viewpoint alone, because anybody can act as an arbitrator, and girls themselves can represent themselves. They don't need. It's not compulsory that must be a lawyer for you to appear, to be an arbitrator, or to appear for yourself in an arbitration matter. Be that as it may, like every matter that is, when you have, the important thing is the presentation of your case first at the hearing, because no matter how brilliant you are, if you have messed up with your evidence, with your proof, no amount of legal gymnastics at the post hearing can help you. So it's important, you have to be sure that you have put all the facts, and don't forget, arbitration is not subject to the same rule as courts. It's a little bit more relaxed. Documents that may not be admissible during a normal court hearing will be used. So, for success, simplicity. Because your arbiter may be an architect, your arbiter may be an engineer, your arbiter may be a musician, depending on what is an issue. Be simple. Let it be logical in your presentation, so that everybody knows, anybody can follow. We are not saying to is a fool, but it may not be a professional. It may not even know anything about the issue that you're asking to determine, but it will listen to you and give you an award based on the facts. Some of them will not even listen to any legal arguments because they are not lawyers. You can make your points. So when you have done arbitration before, an architect in anything that doesn't, you have to bring in a lawyer. When the two of us who are lawyers are making too much legal points, and he has to bring in a lawyer. So it is how simple your argument is and logical that will assist the arbitrator in coming to a conclusion that be to the benefit of your client. Prioritize what is important. It's not all you come in with a bundle, with a busload of facts, of evidence. It's not everything that is relevant to the issue at stake. Because if you have a bidding contract, a construction arbitration, in respect of bidding, I did one night bidding in Abuja, about 50-story bidding. Imagine the amount of documentations you have on that. But the issue was simply, can you terminate the consultants without going through the legal process, without making sure that he has committed something wrong? So you have to distill the important documents, extract them, so that you can see the one that will really help your case. So you have to be simple and then prioritize what is important. Be laser focused. Once you have identified the documents or argument that is in your favor, press those points, because those are the ones that the arbitrator will use as, oh, this one is making sense. Because if you use just a wide spectrum of files and you cannot, which will work both ways, both parties usually have access to the same document, both of you are using the same documents. It is for you to identify the ones that really help your case. Choose quality over quantity. It's the same issue. It's not the amount of exhibits you tender. It is the one that, because we are talking about a contract. Some contracts have been in existence for 10 years, 15 years. So you have most generated tons of documentation between the parties. But you need to find out which one fit into the issue in dispute, that will assist the arbitrator in resolving the conflict between the two. So the quality of your evidence matters. The quality, because they say if you have facts, if you are very strong on facts, you can just point out the facts and see them. You don't need two ranges Supreme Court authorities on that. But if your facts are not too strong, then you may have to use law. And then, of course, the third one, if you have no fact and you have no law, you can bang the table and shout on the arbitrator and say, this is what you must find. But of course, most arbitrators will simply ignore you if you shout on them. And don't forget, and I always tell people, when you are in arbitration, you are more or less talking to God. Because we have done, I think this institute did a research some few years ago. Despite all we say about arbitration, 95% of arbitral awards are upheld. So no matter what you say, it is important for you to get the award in your favor. Setting aside an award is a very difficult process. And we have done research that about 95% of awards in Nigeria, if you go through from High Court to Supreme Court, 95% are upheld. So it is important for you. The most important person you need to convince is the arbitrator, because the court may not be able to assist you, because the constitution is that you choose your arbitrator. It is a private contract. You are the one who chooses him. So whatever it says, you are bound by it. It is very difficult to get an arbitral award to set aside. Now, pay attention to details, because we are talking about the arbitrator has less workload than a judge. In Lagos, for example, now most average docket of a judge in Lagos is about 700 cases. As Osahon has said, if you use a professional arbitrator, no arbitrator, a serious arbitrator will not have, at any point in time, will not have more than 2 or 3 arbitrations doing at the first. So he has more time for it. So he has more time for you to sniff out where you are just trying to mislead him. So you are the one to be sure that whatever you put before the arbitrator is actually the truth, is the facts support the argument you are trying to canvass. So you need to pay attention to details from the beginning. Be very careful in your choice of word when you are addressing an arbitrator and when you are putting across your case. Because as I said, the power he has is the power of arbitrator is so great. It's big. I can assure you it's bigger than that of a judge, because a judge can easily be reversed on appeal. But when it comes to arbitrators, they are hardly reversed. So choose your word wisely. Then if you are going to do post-trial brief, post-hearing brief, or you are going to just address sometimes you can finish your document. It depends on what you agree upon at your plenary hearings, that once you finish with the document, with the witnesses, parties can just address, or you submit a brief. Before you submit that brief, please, when you write it, you think you have done a very good job. Yes. Clean it up. Look at it once again. Clean it up. If you have a junior, let your junior look at it and say, can you go through this and see whether I have omitted something? But once you pass it on, you may not add up. Of course, this affects almost any brief you are submitting. But it's extremely more important in arbitration that once you are submitted, because you submit, you may not hear from the next thing you hear from the arbitrator is that the award is ready. So avoid gambling. There's arbitration I was involved in that I told my client, oh, let us claim damages of 200 million. He said, oh no, what we have lost is over 5 billion. I said, can we substantiate this thing? He said, okay, it's okay. And I said, and he's a lawyer also. And I said, do you know this is not high court where you pay 50,000 naira. The arbitrator is going to be you based on what you are claiming. Whether you succeed or not, it's not the decision of the arbitrator. It is a claim before the arbitrator that determines something. So by the time we got a bill of 5 billion, then the other party a government agency also counterclaim for 6 billion. And our team, our panel arbitrators, they said we should pay 500 million naira as deposit. I can tell you that was the end of that arbitration. So let us be practical when we are settling matters for arbitration. And then the tendency when you are doing arbitration is, oh, I just remember something, let me hide, I want to amend. Be careful with 11-hour addendum, which may change the whole tenor of your case, and arbitrators will not mind because they are going to bill you for it. And so you have to be very careful what you do, what you add on after you have submitted your notice of arbitration. Thank you. Okay.
Thank you very, very much, sir. Thank you for taking us through the whole works as far as the practical aspects of acting as arbitrator counsel is concerned. And this is particularly where the arbitration has a lawyer representing the parties. And it's also important, like you have rightly noted, Leonard Silk, that it's not all arbitrations that have that necessarily would have a lawyer as the arbitrator. As a matter of fact, there's a construction arbitrator that I read a lot of his materials but he's based in the UK, and he says point blank, if you're going to get a barrister, that cost is not going to be part of the cost of the arbitration. That cost is something you're going to have to handle by yourself. So even with construction in the UK, they try and discourage the use of lawyers in arbitration. That being said, in Nigeria, arbitration and lawyers are still pretty much still in the party. So, which is one of the reasons why this sort of webinars and awareness is necessary, so that those who find themselves in a position as counsels to arbitration parties are well informed of what their responsibilities are. So now we'll go into the question and answer session. I want to once again thank the panelists, and I'll crave your indulgence for just a few more minutes. Let's quickly go through some of the questions that has been raised in the course of today's webinar. So I think a number of them have been answered, but at this particular one, I'll probably put to Mr. Osahon. In a situation where the other party is not accepting the arbitration agreement and is insisting on going to court, what should be the response of the counsel on the other side?
Okay, sorry for looking. I think I saw that question on the chat, but I wasn't sure what the person was asking. See, in the case where the other party insists on going to court.
Yes.
Now, basically, arbitration is an agreement, it's a contract. There's a contract that is entered by the parties in anticipation of a situation that will occur in the future. So when we enter, that is why it's an independent contract within a contract itself. And what that independent contract actually says is that if anything in this main contract leads to a dispute which we cannot resolve, we both now agree that it will be sent to a third party, independent of the national courts, to resolve the dispute between us. So the first principle in arbitration is that, I think it's the contractual principle of sancta sus servanda, the sanctity of the contract. You are held bound by it. So you can't insist on going to court when you have signed a contract that says you must go to arbitration. Although I must tell you, again, speaking like an advocate, it's that if it's not in my interest, and I think the ladies advocate did mention, and I don't want to go to arbitration, as it were. It's just to conceive the issues in a way and manner that they become non-arbitrable. And that way, because you cannot contract outside of the law. So, but primarily you cannot insist that you're not going to arbitration. you're bound to go to arbitration. I did have an experience in the UK though, where there was an arbitration clause. My client was slow in responding, even though he hadn't taken any step. And once the other side had filed the action in court, as it were, and they had asked for judgment on admission, we then raised an application for an objection of jurisdiction, that there's an arbitration clause. And the English court just said that you haven't taken any steps towards arbitration. You obviously have not shown any interest towards resolving these disputes, let alone in arbitration. So it's deemed that you had no intention of going to arbitration. And so they're not going to actually honor the arbitration clause contract. But our courts have not reached that level of, I would say, strictness of flexibility. I would say we're still a bit rigid with the way and manner of the arbitration clause. Once an arbitration clause is there, the average Nigerian court is going to insist that you go to arbitration.
Okay, thank you, sir. Just one more question for you too, sir. With respect to terms of reference, what exactly is it? I saw that there was a lot of interest when you talked about it. And how can that be distinguished from the notice of arbitration?
Okay, the notice of arbitration is what initiates the proceedings. For want of a better word, is the first gun, the first sound you hear in arbitration. The notice of arbitration is what tells you what spells out the issue of the issues in difference of which adjudication is then sought, as it were. So it announces to the other side that there is a dispute. This is the dispute, and we want the result by adjudication. Now, the terms of reference. Now, the word terms of reference was actually is what is used in the ICC rules. And so it is sort of pervaded, gone into, but it's not different from your issues of determination. The only thing I say to people is that, however, when the nomenclature or the phrase terms of reference is taken in by an institutional body, be sure to know what it encompasses by that institution. Do not say because this institution uses it, this institution uses it, because in the institutional rules, they're defined, as it were, but it's not different from your issues of determination ordinarily. Now, what I've advocated is basically, it's always a good point to cement the jurisdiction of the tribunal, define the issues, and like my friend Agbola said, when you're looking at the jurisdiction of the tribunal, or he made a point, he said, be wary of amendments, subsequent introduction of issues. Now, the easiest way to make sure that does not happen, as it were, is to drive in the terms of reference. And at the point where the terms of reference comes in, it's after the first preliminary meeting. When notice of arbitration is given, as it were, it goes to the counterparty. Is asked, depending on what the arbitration clause says, nominate one person, or nominate three, we'll choose one, or it goes to an institutional arbitrator like the institute, and institute nominates an arbitrator. The arbitrator calls for the first preliminary conference meeting. Now, the first preliminary meeting is to identify A, the parties, B, the contract in question, to be sure that indeed there's an arbitration clause. And 3, the arbitrator chosen or the tribunal chosen is qualified under the agreement to so cease. Now, after that meeting, or during that meeting, the arbitrator will then ask parties, how do you want the arbitration? Oral, documentary, how much time do you want to file your pleadings? How do you want to exchange it? Do you want a bundle of documents? And cool. That is when you as counsel will also say that we will also, after the exchange of pleadings, at the close of pleadings, parties would prefer that parties also sign terms of reference. So the terms of reference is then extrapolated from what has been submitted in the pleadings as the facts leading to the issues in difference. Now, once you've extrapolated it, and normally, again, like the ICC or other institutions, it's between counsel. The arbitrator is hardly ever involved. The arbitrator says two of you agree. Maybe the claimant counsel does the extrapolation and shares it with defense counsel, or defense counsel does the extrapolation depending on the understanding, shares with the claimant counsel, or both parties do the extrapolation and exchange it, then they then decide to merge it. And of course, a lot of maturity is required. When you then merge it and you agree, all sides sign, the arbitrator sign. Like the one I referred to, that was where, because I didn't want the arbitration to go on, as it were, we couldn't reach an understanding. And when the arbitration tribunal said, well, this is how I see it, I said, well, I don't agree. You have gone beyond the disputes as well. And he said, well, I don't think so. I said, well, I don't agree. And unless I concede to it, you can't move forward. I knew that. So for the next 1 year, we're looking at TR. And when the parties got sufficiently frustrated, we went to settle. But I'm not recommending it, but it's a commercial dispute, I always say. Look at what's in your client's best commercial interest.
Duly noted, sir. Thank you very much, sir. My next question is for the Learned Silk, Mr. Agbola, and this is actually from the audience. It's from Professor Nwakasu. What is the future of arbitration? In 2 minutes, sir, because it's a very broad question. What is the future of arbitration in Nigeria?
Well, the future of arbitration in Nigeria right now is not very bright as far as I'm concerned, unless we can do certain things to eliminate the delay. For example, I don't see any reason why challenge or arbitral awards should go all the way to the Supreme Court. It defeats the purpose. I have done arbitration that lasted over 20 years from arbitration up to the way to Supreme Court. So if you are going to do arbitration, then let us do it the way it is done in civilized parts of the world where arbitration is standard. If I know that the association and other stakeholders group are pushed for the amendment of the ACA, I was thinking that we'll get it done this time around, but it seems that has not been done. And this legislative session will be ending on June 5, if I'm correct. So very doubtful that will be done before then. We need to, because if I have to spend millions of naira, sometimes millions of dollars to do arbitration, and then I have to wait for 20 years to get the benefit of that arbitration, I don't think I will. It's something I will recommend to anybody. Why not just go through the cost system straight away? So, but arbitration is where the whole world is going. People are moving from court-based settlement of disputes to private settlements of disputes when it comes to commercial disputes. Nigeria needs to get on the train fast. We have now things have changed. When I started practice, there's arbitration is something very esoteric. Now it is being, you hear it every day now. So if from that perspective, you may say there's a future, but whether that future is bleak or bright is a different thing. That from where I stand today, it is bleak because of the intervention of the judiciary in the arbitral process, which substantially delays completion of arbitration matters. Thank you.
Thank you very much, sir. At this point, I'd like to ask our distinguished panelists if they have any last words before we call today, before we call the session to a close, starting from Mr. Osahon.
Starting from me.
Yes.
Thank you. I will just chip into what Mr. Agbola said in response to the question you posed. Future of arbitration, I agree with him, is extremely bleak. Why so? Two fundamental reasons. There's unnecessary and unhealthy interference by the courts, particularly when it's ongoing. I had an arbitration I did as counsel, and where the court of Appeal held that because the arbitrator refused to stay proceedings when there was a pending application in the High Courts, the Court of Appeal set aside the proceedings. And what was instructive about that, and that's the Court of Appeal, so they're now the Supreme Court. What was instructive about that is an international arbitration. So why would anybody, because always remember, the local courts, the courts and where the seat of arbitration is, have powers to interfere should they choose to, even though they ought not to interfere. So when it is perceived that the Nigerian courts take it upon themselves to interfere in ongoing proceedings, then your push to make arbitration Nigeria an arbitration, a regional center for arbitration, falls very flat on its face, as it were. So there's a need for us to, first of all, understand the tenets of arbitration and begin to re-educate ourselves, both as users of the platform, advocates, and the courts. Then secondly, there is a need for the business community to be engaged as to the benefits and the nuance of arbitration. They are actually the owners of the process, not the lawyers, not the judicial system, it's the business community. And arbitration is actually to promote the efficacy of business by reducing the manner, the length, and the money spent on dispute resolution. And it's not supposed to be as expensive as it is today. So when you also look at the cost element in it, it's now become such a niche and expensive and esoteric. It's not supposed to be. It's supposed to have been watered down, simplified litigation. Now, you now need to be an expert to even understand arbitration. So those are the things that make it bleak. And I will say, as advocacy groups, there is a lot of work to be done to ensure its sustainability and to make Nigeria as a veritable destination with regards to arbitration practice. Thank you.
Thank you very much, sir. And Leonard Silk, for many of us who look up to you and of course Mr. Osahon in the arbitration council or arbitration advocacy space, what is your advice in building a career in this space? And let this be your concluding statements for the session, sir.
Thank you, Foluke. Like in everything, integrity matters, consistency matters. When you are engaged as an arbitrator, you need to, despite, of course, when you are, lawyers are going to appear before you, you're a lawyer, I'm a lawyer, you're a lawyer. So really, most matters now we know ourselves, those who, both parties. But it should always be about your integrity, because when you are appointed as an arbitrator, whether by luck, or your friends appoint you, or because you know the CJA of Lagos State, or you know the CJA of the Federal Court or somewhere, and you're appointed. It's only one chance you have. If you mess it up, you are not going to get another one. And that is why you need to be hardworking, and you need to prioritize. When you are, don't take a job you don't have time for. Because I say a lot of, sometimes you say arbitrators will say, oh, I'm so busy. Then why do you take it? You are supposed to, it's not a matter you go for adjournment. Each time you go for it. I can tell you I did one matter during COVID. I acted as I was a counsel in that matter, but I must say I was so impressed by the panelists. We had only 2 sittings and they finished the matter. And that it should be. Not the one that you keep on coming, and but of course, it's also a function of how the party themselves are addressing the issue. But for young people, you need to network, you need to let people know you are available, and you need to handle every matter, every application you will receive, whether as a counsel or as a arbitrator, as if life is at stake. Because sometimes life is at stake in your decisions you take. Thank you.
Thank you very, very much, sir. At this point, I want to sincerely thank the distinguished panelists, including Leonard Silk and Mrs. Adesina, who had to quickly leave a little earlier. And I also want to thank the Nigerian Institute of Chartered Arbitrators for the opportunity to moderate today's session. I will now hand over to our dear registrar, Mrs. Oshodi John, to do the vote of thanks and also close out on the session. Over to you, ma'am.
Thank you very much, my able auditors for the Akinmoladun. Like I said, you don't justice to the body shop section. I also want to say a big thank you to our distinguished panelists. Mr. Osahon, thank you, my brother, always available to be of assistance to the institute. I think this is the second time we are going to be allowing us to learn from a wealth of knowledge. I hope that we come lucky and keep the dose. Thank you so much, Mr. Agbola, SAN. Thank you, sir. As usual, just like Mr. Osahon, you've always been there for us. All we have to do is just knock on your door and you're always willing. Thank you so much for being willing to let us share from the wealth of knowledge that you have. It's always exciting listening to you as well. This is additional. I also want to thank her in absentia because she also did a good opening for us, and it's been a fantastic time. Even me as a registrar, I've learned a lot. Can't tell you the notes that I have taken. So I've taken a lot of notes, and I know that I'm not here sitting as a registrar, but also as a participant as well, to learn from all the wealth of experience that are here today on this panel to talk more about arbitration advocacy. I just want to also go ahead to encourage today's audience to say, please, it doesn't stop here. Just like Mr. Osahon said, I'm challenging you. You need to invest in books. You need to invest more in webinars. This webinar was circulated to over 5,000 members of the Institute, circulated widely, we even sponsored it. But I can tell you that we didn't have up to 200 participants. And that's to tell you that we don't invest in ourselves. But we think that once we are called upon to handle the matter, either at the council or the tutor, it's going to work. It doesn't work like that. And that's why we have the challenge that we have in our climate. Just like Mr. Osahon said, unfortunately, Mr. Bola has said the future is very bleak, and of course, I understand what he's saying. It's because of things like this, because I believe that if we invest more and we know our onions either as counsel as arbitrators, then we will do things differently. And we will also be able to even challenge the courts in the cases where they interpret wrongly and tell them what they ought to do. But unfortunately, it's not happening because even we, the counsel and arbitrators, don't understand the arbitration process in its entirety. And this is why we have to keep doing what we are doing as an institute to create more fora for us to advocate more, sensitize and enlighten professionals, not just lawyers, to understand that there is a place for us to be able to up our game if we really want to compete, internationally. So this is just the first of webinar we're having, and given the general opinion that we have received so far, we're going to be having a course on arbitration advocacy, which is going to be a certified course separate from the usual, training for arbitrators. Because we see that there are some professionals that want to be advocates, and so they definitely will need this. And so we would, going forward, now begin to have courses where professionals can enroll and be trained and certified as arbitration advocates, so that we can up the game and do things differently if we really want to be reckoned with when it comes to arbitration internationally. So once again, thank you so much, my honorable panelists and moderator, as well as our participants for today. I'm very excited about all the reviews we've had. There have been a lot of reviews, a lot of commendations from the audience for our panelists, our moderators, and the institute. So for me, this is a big one, and we'll keep pushing the frontiers. We are hopeful that the future of arbitration will be different. Maybe when we have the new regime comes on board and we have somebody that understands the importance of having an up-to-date arbitration and mediation act, as well as ensuring that we no longer have to go through the first steps. That you just have the first court of instance, we go to the court of appeal, and then arbitration ends there. There's
I think the rain finally got to your point. Agbola had warned that it was really cats and dogs and a few other pets.
Very, very true.
So Foluke, maybe you just give us a final word.
Okay.
Yeah, I'm sure she's back. Yes.
She's back.
I guess Zoom says you're speaking too much, so it's time to go. Thank you, everyone. Thank you.
Thank you.
Thank you, everyone.
Thank
Thank
you.
Bye.
Thank you, everyone.
Bye.
Bye.
Thanks, Foluke. Thank you so much.
Yeah,
for
most welcome, sir. Most welcome.
Okay.
Bye-bye.
Bye-bye.
Thank you. Thank you, our distinguished members as well. It's good to have you all on board today. Thanks a lot. Have a wonderful day, and I wish you
You
good
too.
arbitration. Go forward.
You too.
Thank
You
you.
too.
Osahon. We'll touch base with you again and again. Okay. Thanks a lot.